Okay, good afternoon, everyone, and welcome to this session titled "Your Freedom of Expression versus Mine. Who is in control?" My name is Cristian, and I'm going to be the moderator of this working group this afternoon. I hope the technical issues are set. I'm very pleased to introduce to you our speakers today. At my right, Professor Wolfgang Benedek from the University of Graz. He's a former director of the Institute of International Law, International Relations at the University of Graz, also a lecturer at the Diplomatic Academy of Vienna and at the European Master Program on Human Rights and Democracy in Venice and Sarajevo. I'm also glad to mention that Professor Benedek is also a member of the Council of Europe expert group drafting the Council of Europe Guide on Human Rights of Internet Users. We also have Mr. Piers O'Donoghue from the European Commission, Director for the Future Networks Directorate of the DG Connect, dealing with policy development and research supporting the digital single market. Also with us today it's Natalia Mileshik, lawyer and public policy expert dealing with digital rights, copyright reform and openness. Irina Drexel, the national coordinator of the No Hate Speech campaign of Romania, who will speak about a recent report on freedom of expression in Romania. And last but not least, it's Georgi Gvimradze from the public broadcaster of Georgia. He's the director of news and current affairs, also an advisor to the director general of the public broadcaster, and I believe also relevant for the topic he will tackle, the one of religious feelings versus freedom of expression. Georgi is a graduate of the Theological Academy of Tbilisi, so I think that adds to the ingredients that we need for this session. But before going to the speakers, we will hear from from Giacomo. I'm a bit lost in my papers.
Can I introduce myself?
That's relying too much on papers. So Giacomo Mazzone, who's the manager of the public service broadcast, who worked in public service broadcasting and media for 20 years. I can pick up and mention here international companies like Euronews, Eurosport, and RAI. Giacomo will brief us about the plenary session of yesterday as an introduction to the debate that we will have. Please.
Thank you very much, especially for the discount you made me, because I work since 30 years, but 10 years less makes me younger, so good. Not true, fake news. And I have to report about the yesterday's session about fake news, so I want to debunk the first fake news that you gave. The session of yesterday was, I think, very interesting and gave some hints that are important to be heard before to go in the discussion of today. I think that what was important yesterday is Claudia Luciani in his keynote speech that at the very beginning of the session said that fake news and misinformation have a big impact on democracy, on citizens' life, and so that need to be tackled because of that. Claudio Cesarini from the Commission said that the Commission itself finds itself between Scilla and Cariddi, between find effective remedies but without hurting human rights respect. That is crucial for European values. There has been other consideration about the banking activity, the source checker, always Cesarini telling that, that need to be financed. This is an activity that has to be financed. He said that this could be something that could become in itself a source of revenues. For the moment, it's only a source of cost for the traditional media. He said that there's an activity that needs to be done hands in hands with the platforms, because if not, it's not effective. He raised the question, who control the controllers? And he gave also an answer saying that peer-to-peer could be the best solution. And he said that the work that the Commission has started will be implemented before the end of the year. And they see that the beginning of next year, until the election 2019, the European election, will be the perfect test time for all the activities that the Commission has put in place. Anna Skalasviskili, sorry for the pronunciation, said that we need to differentiate remedies because in the same information disorder box we have fake news and propaganda, and probably the two needs to be curated in a different way and need different answers. Patrick Pennings provoked, as Council of Europe provoked a little bit the audience, saying that in 22 out of 28 countries, media are the less trusted institutions. And so he said that this leave room for improvement. He especially said that only 1 out of 4 trust social media as a source of information. Probably because I was in the room, he mentioned that the public service media are going better and are even improving in the barometer. So, but probably was just for me, I don't know. And he said that we need to face as a society with the news skimmers and the news avoiders that are relevant phenomena, the people that doesn't want to, that have a very small view on the news, doesn't go at all in deep, and the avoiders, those that don't go at all at the news because they don't find the news interesting or relevant for their life, and both are very worrying phenomena. And he said that the answer of many of these people that are skimming and avoiding is to cocooning, so that they look into media or into messages that reassure them on their own positions. And that this is, of course, for the society a disaster, because it means that you will not go for the best option, but you don't go for the option that you like more, even if it's not the right one. Google was present in the debate, and they gave us a long list of technical possible solution to the problems. It seems that they look only into algorithm solution or technical implementation that could solve the issue. Not everybody in the room was in agreement with that. And then finally, I think the final conclusion of the reporter of the session was that remember us the reason of all the debate. Democracy is only about making informed choice for citizens. And if I can add something on my side, when I start to study journalism 20 years ago, as you said, but let's say more. The most important lessons that I learned is that you never have to say to your viewers or your listeners or your readers what they want to listen. You have to report them, especially the things that they don't want to listen. And I think that this could... Exactly. Thank you.
Thank you very much for that summary, and of course I apologize for mixing up the numbers. Let us get into the debate, and before giving the floor to the first speaker, let me also mention that we will have as an informed speaker from the floor my colleague Menno Etema from the Council of Europe's No Hate Speech campaign. And then about the organization of this work. We will give to the speakers somewhere between 5 and 7 minutes to make their intervention, after which we will open the floor for questions. We'll try to get as many interventions as possible. Please bear in mind, let's bear in mind altogether the size of the group and the time that we have, approximately 90 minutes, well, 80. From now altogether, in order to allow as much participation as we can, and also to be able in the end to arrive to a couple of conclusions. So I will go first to Irina Drexler on the country report on freedom of expression in Romania. Please.
Thank you.
I think we have to.
Yes, I have to use my...
Okay.
Mm-hmm.
That can be done.
Thank you. Hello, everyone. So, yes, my name is Irina Drexler. I am, among other things, I am an independent consultant and researcher on human rights and discourse analysis, also internet governance. But also my role here is as the national coordinator of the No Hate Speech Movement campaign of the Council of Europe in Romania. This campaign was also implemented in Romania, and it started, so I'm telling a bit about the context of the report that I'm going to briefly present to you. So the campaign, the No Hate Speech Movement campaign in Romania, was initiated by the Ministry of Youth and Sports, that has selected 9 NGOs in Romania active on human rights. Among these 9 NGOs, there is one called Active Watch, which is monitoring the press in Romania. The organization basically advocates for human rights and for freedom of expression, anti-discrimination, and media education. These are the 3 pillars. And in their work, they are developing each year a report, 2 reports, one on freedom of expression, with special attention to the freedom of expression of the media in Romania, and another one which is connected is a yearly report on the state of hate speech and intolerant speech in Romania. So briefly, the report is 200 pages long. I'm not going to present all the cases that they have come up with regarding the state of freedom of expression in Romania in the previous year, 2017. But it's a newly launched report on the occasion of the World Day for the Liberty of the Press, so at the beginning of May. If I were to summarize, the main idea of this report is that media in Romania has greatly contributed to the polarization of the society. The politicians, on the one side we have the politicians and the state institutions, and on the other side we have the citizens. There is a tension that the authors from Active Watch organization notice and state in this report, which has arisen immediately after the new elections in Romania in December 2016. So after these elections in December, if you may remember from the press, from the international press, in Romania we had huge protests which amounted to some 600,000 people in the streets, protesting, among other things, also against corruption and new developments in the political sphere in Romania, but also against the silencing of journalists who were investigating these corruption initiatives by the new government. And also, the polarization is not just between the institutions of the state and the citizens, but also between the press, which is the good press and the bad press, so to say, or the press of the government and the press of the opposition. And the authors remark that there is not a real press for the citizens and for the public interest of the country and of its citizens. One of the first initiatives was of the state institutions that is remarked here in the report is that public gatherings of people who are trying to protest against disinformation and against the initiatives of the government have been discouraged also by sanctions given by state-controlled police, and the protests have been described in the press as being a way of manipulating from using sources from outside. It was conspiracy theory, which is a common theme in other countries as well. And also with regards to the social networks, the state has, or the police has, and some courts have ruled that the press needs to take down completely all articles that are criticizing too harshly the ruling parties and the government. So it was a case of freedom of expression of the journalists being attacked. Also, the report notices that just like in the case of the national television in Romania and the national radio in Romania, who have faced a new leadership change once the new elections or once the new government was installed, it was also the case of the National Press Agency, who was being targeted for a similar initiative, trying to have the leadership changed, to have a more favorable one for the new coalition that's governing the country. But on the other side, on the plus side, there is also a more active role that the National Council on Audiovisual has been taking since, or in the period that the report is looking into, in 2017. However, despite this institution being more active, in fact, there is not a predictability on the sanctions that it gives to televisions, to radio stations, and to TV stations. And it's not a predictable sanctions, and also disproportionate sanctions concerning who is doing or who is saying what. The report also mentions pressure on journalists. In the sense that, for instance, investigative journalists have been attacked, or their parents have been attacked, or their cities have been spread with graffitis or messages inciting to hatred towards those journalists who were doing investigative work on both the opposition and the government, but especially for the ones who are criticizing the decisions or initiatives of the coalition. And also there have been more controls, financial controls for the publications who are being critical. And in the sense of the discourse, the public discourse, because of the trends in mass media, there has been a radicalization that the authors of the report have noticed with sanctions also at the level of the civil society who are trying to be active. And because I have only 1 minute, I will not go into the other findings of the report, but just to mention that this report is connected to the report on hate speech in Romania, and I will be available to speak more about this and the No Hate Speech initiative in regards to freedom of expression of society in general. Thank you.
Thank you very much, Irina, for that. I think it's a good opening also to start from a specific case rather than having it at the end. I'll pass the floor now to Natalia Mileshik on copyright as a tool to restrict freedom of expression. Or should there be a question, I think?
Yeah, there is a question mark afterwards, of course, the statement. So hello, everyone. It's really good to be here. Since I was so nicely introduced by the moderator, I will skip this part and go directly to the question that probably interests you. Why are we talking about copyright during the session on freedom of expression? And of course, for many of us in this room, copyright might be perceived only as property right, as ownership right that protects creativity and those who should benefit and those who should earn money on their creativity. But at the other side, you can also look at the copyright as the way of restricting and limiting somebody else's ability and possibilities to publish things online, for example. So restrict, in a way, freedom of expression. The question is if it's legitimate or not. And European Court of Human Rights many times stated in many decisions that copyright presents risk to freedom of expression. And I was thinking about the example to share with you, and I didn't want to become too political, so I decided to go for non-European example. If you Google or Bing or whatsoever, like whichever search engine you use, notice and takedown and the president of Ecuador, you will find plenty of articles showing how notice and takedown mechanism, so the mechanism of implementation of copyright online, was used for several years to take down the commentaries against President of Ecuador. So it's happening. And coming back to ongoing European Union copyright reform, I want to underline it's ongoing. And that's why I will focus on general concepts that were introduced. I I won't go into very legislative details. I have to apologize to those of you who are really experts in copyright. I'm looking at two gentlemen on my left and my right. So because we simply don't have time for this, but I just wanted to show you how freedom of expression is visible in this copyright discussion, and where are tensions and where are things we should care about and be very sensible about. So first of all, there is so-called, lawyers love to operate with numbers. So it's so-called it's Article 13, that at the very beginning was the idea to implement filtering obligation for platforms that host user-generated content. And I must ask you, who ever posted something online that you created, generated, wrote, anything? Only 3 people? 4 people? Non-comments, non-articles, like academic articles, non-photo on Facebook. Guys, you don't share photos on Facebook, you do. So imagine the situation where everything you post online must be scrutinized, must be checked before being available online by any platform that hosts this kind of photos, articles, comments, and everything, in order to avoid copyright infringement. Right now, we agreed in the European Union that it should be something like notice and take down. So if there is copyright infringement, you should let know the platform that something like this is happening, and then platform has to take certain steps. But with this proposal, of course, in the worst case scenario, I want to underline it that I'm talking about worst case scenario, platforms will be obliged to monitor proactively the content published online. So you can imagine what might be the outcome, and also the idea of automatic filters will introduce. So it usually will be not humans behind it, but artificial intelligence probably, especially in the case of big companies. So that's the first thing, and I want to let you know that at the end of November 2018, 80 organizations from across European Union sent a letter to officials in the European Union naming 29 other letters on this issue. So like 29 other letters, like public letters, were published before, saying how harmful it might be for freedom of expression if there is private entity that has to monitor everything you do online. And second very controversial article is Article 11, that introduces new right for press publishers. So besides having copyright on the content that is usually in the hands of creators, or sometimes is acquired by publishers, publishers will be granted additional layer of protection, and they will be able to regulate who and how use links and snippets and short parts of the things published in their newspapers online. And of course, I'm saying again, I'm talking about the most radical proposals we seen during this discussion. And of course, we all agree that press publishers in European Union right now are struggling or are sinking, as somebody already told during previous panel on copyright. But at the end of April, 169 copyright academics wrote to also European Union institutions saying that this solution in this very radical form can be very restrictive to freedom of expression. And since I was already given a notice that I have to finish in probably 30 seconds, I just wanted to underline that this is an example how seemingly not human rights related regulation, because copyright is proceed in the European Union under a digital single market agenda. So it's mostly market oriented program to enforce and create common digital market for the whole European Union, might affect various rights, in this case freedom of expression. So, and it shows that we should always be aware and very conscious about human rights, whatever we proceed. So thanks a lot for this.
Thank you very much, Natalia. And we turn now to Professor Wolfgang Benedek on challenges for intermediaries in regard to respecting freedom of expression.
Thank you very much. I would like to address to some new challenges, not so new for you maybe, but I have to say when I published together with Matthias Kettemann this book on freedom of expression and the internet with the Council of Europe Publishing House 5 years ago, we had a different focus and different challenges in mind than what we see today. In the past, the internet was mainly seen, or the internet companies were mainly seen as facilitators of free speech, of dissemination and so on. And today we discuss much more the problem of gatekeepers and of responsibility or accountability of such intermediaries. And so I would like to take two examples. The one would be the right to forget, and Google in particular. The other one would be the content management by Facebook. And the concern is to say that there are standards and procedures in place which lack transparency. There are decision makers where we do not know neither their qualification nor where they work from, how they do it, and so on. And there are problems also with regard to the right to remedy. This would not be so important if these platforms have not become public interest because they provide a public space in which we all operate. Now, regarding the right to be forgotten or the right to be erased, there was the famous Google Spain case, but in the meantime, we have the GDPR, which has also already been discussed here. And in this new regulation, we find Article 17, which says that this restriction shall not apply to the extent the processing is necessary as for exercising the right to freedom of expression and information. So this exception for the right to freedom of expression and information is very important. What is unclear is its interpretation. And the GDPR clearly says that in the public interest, when it is about legal claims and so on, then there has to be this emphasis on freedom of expression. It goes even further. In Article 85, there are certain exemptions seen for academic, artistic, library expression, and so on. So the question is, how do platforms, social platforms like Google, for example, implement that now in practice? If anybody can help me in understanding this better, I would be very grateful, because the public information existing is very limited. Certainly we could have some ideas how this is being done, and I do not envy Google for this task, by the way. It is kind of the position of the EU and others that they should not interfere with their work, so it is a kind of self-regulation issue. But on the other hand, there are standards, in particular the ones I have mentioned. Also, the issue is if Google is delisting only in the EU or beyond. And if you have, maybe if you're aware that the Canadian Supreme Court ruled last year that certain search results have to be blocked worldwide. So here we have also different standards. Then I go to say a few words on Facebook, and here the transparency report is very interesting, sorry, I wanted to say something on the transparency report of Google first. And here Google has published that 686,000 requests to delist have reached it, and it is referring to 2.5 million URLs, of which 44% have been delisted. So that should give us also an idea that there is a very high delisting rate, but on what basis this delisting finally has happened, and if human rights criteria have taken into account, is uncertain. As we just heard about copyright, by the way, there have been a delisting requested for 3.5 billion URLs under copyright, and 90% were delisted. Again, this shows a different dimension which exists in that field. Now, a word on Facebook, and here I would like to pose 3 questions to you, which you can see here already. And I would ask you for your opinion, yes or no. So, should there be should information of this type be deleted or not? Poor black people should still sit at the back of the bus. Is this hate speech, yes or no? Who says yes, please raise your hand. Who says no? Hardly anybody. That's interesting. Actually, Facebook is considering that this is not to be relisted because race is a protected category, but social class is not. 92% of people who have been asked by New York Times had a different opinion. Actually, also my students which I asked on that. Second example, white men are all assholes. Yes or no? I mean, it's not whether you agree with the statement, but whether it should be. Yeah. So who says yes? Who says no? Okay, you are a bit split, I see. There are many undecided. In that case, it was yes, yeah, because race and sex is at stake. And finally, the third one, I'll never trust the Muslim immigrant. They are all thieves and robbers. Should that taken up out? Yes or no? Who says yes? Many say yes. Okay, you are not aware of the of the Facebook policy because it is no. Immigrants are only quasi-protected, only in context of violence, but not in the context of exclusion. So what do I want to show with this? That these criteria are often used in a counterintuitive way. I do not want to say that we should always have a poll, you know, what the people want or so, but I want to say that it's counterintuitive, and also some other such counterintuitive decisions have been corrected, like, for example, targeting black children, which are now better protected because the category of age has been included. Now, this brings me to 2 points more, and this is when you look how this is done, then you realize that it is often done through algorithms and in a semi-automated way. So the question now is, how can you develop the algorithm to take human rights, freedom of expression in a way better into account? And here I cannot but emphasize also the study of the Council of Europe on algorithms and human rights, which you can find over there, and which deals with this in a very good way. And also we had just a flash session on the other side of the road, which also dealt with this very well. So I cannot go into details. But the issue is the challenge, how to organize this self-regulation through a semi-automated decision-making procedure in a way that it has not a chilling effect on freedom of expression, and that the process in general is foreseeable and hopefully also legal in the sense that it does take human rights into account and maybe also provides an effective remedy. So if you're put in the so-called Facebook jail because your account is blocked, you would like to know why, and you would like to know which remedies you can take, and this is not sufficiently the case. I would like to end with another document which you can find over there, and this is the guide for you. This is the new guidelines for internet intermediaries of the Council of Europe. You can also find it over there. The basis is actually the UN guidelines on business and human rights. And they apply this to gatekeepers, to intermediaries, and they come to certain conclusions and recommendations which are quite important when it comes to this companies, because they say standards and practices of content moderation should be publicly available and the user should be informed. Restrictions should be based on principles like least restrictive approach and so on. And we have no information whether this is happening or not. Now, I'm not against algorithm as such. I only recently found out that the European Court of Human Rights itself is using algorithm in filtering applications in order to find out whether there is human rights violation or not. So, if that is the case, then why not others as well? And if we have in mind the large number of cases at stake with which such companies are confronted, it is, I think, understanding that they use that. But the question indeed is how these algorithms are being developed and to what extent there can be, what we heard in the other panel this morning, an efficient transparency, which does not mean that we have to know all the details of the algorithm, but we have to be given a basic understanding and maybe also the possibility to participate in the discussion how it should be shaped. Thank you very much.
Thank you very much for that insightful presentation. I think it linked very well with the previous one. And now we move to Piers O'Donoghue on platform and how to tackle illegal content while ensuring freedom of expression and information.
Thank you very much and good afternoon. It's very interesting to hear the other speakers. I would just like to, first of all, just do a quick inventory as to what we do in the European Union with regard to both illegal content, but also, of course, in relation to disinformation, which are two different categories of issue. For years, our rules have been set by the e-commerce directive, which had the objective of helping the internet to develop. We're talking about rules developed between 2000 and 2002, while promoting the freedom of speech. So it did put obligations on intermediaries, but it made sure that the intermediaries were not liable for content. The only situation in which they were liable for content was where if they were clearly notified, and even then there were certain protections. More recently, very recently in fact, and this is where in a way we diverge now between illegal content and other issues, is that the Commission issued a recommendation on measures to tackle illegal content online. And that was driven by a number of different controversies, but of course would in the first instance, for example, be targeted at online material which was promoting terrorism or indeed hate, or child pornography or other issues. Now it does of course in some cases touch on copyright, which I'll have to come back to because of the examples that were given to us. And then very soon after that, very recently, the Commission issued a policy communication on tackling online disinformation. That was in fact one of the subjects of the plenary session yesterday. I won't go into detail on that, but it was based on the report of a high-level expert group, which did help us to focus our thoughts a lot. The last element that I would mention is actually the Charter on Fundamental Rights. So one of the fundamental founding documents of the European Union, which is now and has been for some years an integral part of the treaties and is operative as well as just a statement of a key set of issues. What do I mean by that? For example, the very famous Court of Justice ruling, the first Facebook case, the court based most of its ruling not on specific legislation or even on the treaty, but based its ruling on elements of the Charter. So this is a dynamic and effective way of protecting different rights. So we have that set of policies, but I must stress that while the e-commerce directive, the original piece, was a piece of legislation, it did not impose many obligations. We do set out now a set of overarching principles and objectives which are in line with the Charter, but the approach we then take is soft law and a voluntary approach, so self-regulatory initiatives, whether it's in how the e-commerce intermediaries organise themselves or with regard to monitoring. There are no general monitoring obligations, and in fact our Vice President ANSIP made it very clear that there would not be general monitoring obligations. I think anecdotally it's also very interesting to note that as a former prime minister of a country that was under the Soviet bloc until the early 90s, when we first discussed this issue with him a year ago, he said, "This is very important, but there will be no Ministry of Truth." This is obviously looking back to the Soviet era, in which we could not put ourselves in the position or allow any member state to put themselves in a position in which the law decided what was disinformation, what was fake news, what was appropriate or not. We had to have an independent, transparent and self-auditing process if we were to try and tackle online disinformation because of the implications, the serious implications potentially for freedom of expression. So everything I've said confirms what we said we were talking about at the start, your freedom of expression versus mine. It is that this is all a balancing act, that there is a very real tension between different public policy objectives and human rights, and even between those different public policy objectives. So we can be criticised and hopefully will constantly be scrutinised for what we do to make sure that we get it right, and we have to be in a position to rapidly adjust if we do get it wrong. But we do have to do the impossible. We have to consider and then somehow get a balance between the implications of online disinformation for democracy versus the freedom of expression. So in the summary report that we had of the plenary session, it was clear that we cannot legislate for or against that unfortunately large group of people who are not interested in, are not consumers of news, or who actively avoid news, which leads to confirmation bias and which leads to a lack of exposure to anything but the most sensationalist and probably manipulated news. But we can create the conditions why or how that we can maintain a strong journalism and maintain a strong freedom of expression for those who are prepared to take the time to listen. And then finally, as Natalia did mention it, Natalia, no, I am not an expert in copyright law. I was relieved when you said that you weren't going to talk about the EU example, but then you talked in detail about the EU example, and I'm not really the expert to respond to you. But clearly this is another example of this tension, where there are, of course, going to be problems with regard to an outright ability to express oneself and the rights of holders of copyright. And also those who work hard and invest in the creation of news and content. Because we are seeing a situation in which what I would call independent, and I know I heard a laugh when the phrase was used earlier on, but quality journalism is maintained and preserved. That quality journalism is essential for maintaining democracy, and so it is actually this is where the inherent contradiction, or rather tension, arises. That we need well-resourced journalism so that we can actually have sustainability and independence in that journalism, whether it is printed or online or broadcast. And therefore, their material needs to be protected. But the provisions, which I know you are an expert in, which the Commission proposed and which are still under negotiation, so the Commission has slightly lost control of its text now, did make provisions for the use of hyperlinks and snippets, did recognise that there were legitimate uses which were exceptions to the right of copyright. Parody, for example, is one of them, and that's very important because in regimes where, as we've heard an example, where a head of government is not happy with the way that he or she is being portrayed, or that the government is being portrayed, parody is, of course, a very useful civil society way of agitating against undemocratic regimes. I'm just thinking back to IGF 2014, which was in Istanbul. I don't know if anyone else was there, but that was just when the Turkish regime had introduced they had shut down Twitter because there were Twitter accounts which were exposing allegations of corruption among members of the government and members of family of members of the government. And that didn't please the regime, so they shut it down. And that's the sort of thing which we all want to avoid. But we do, nevertheless, when it comes to legitimate journalism, we have to preserve that. It is essential, in other words, for democratic society and accountability. So even if it means that some people cannot reuse the material, it's a justifiable cost in the view of the policymakers who decided on these proposals. So that's really the point I wanted to make specifically in relation to copyright. Thank you.
Thank you very much. Thank you. And now we are going to the last speaker, Georgi Gvimradze, on religious feelings versus freedom of expression. My personal feeling is that this is a debate that it's gaining weight in Georgia nowadays. I think it's very timely to discuss it. Please.
Okay, thank you. As you were told, I'm George Gvimradze, and I'm representing here the public broadcaster of Georgia. So it's my honor and I'm pleased to represent this organization on this very interesting event. First of all, I would like to express my appreciations to organizers of this event, giving me an opportunity to share with you my concerns and questions, which are not easy to answer regarding the topic of freedom of expression versus religious feelings, even realizing that maybe even this is the wrong point to put religious feeling versus freedom of expression. But anyway, I'm happy to relay that this discussion finally came to my country because we are, despite we are talking about that for a long time now. First of all, as a media representative, I should admit that there is no public space yet for qualitative and academic discussion of this issue, issues of similar importance. And that's why I was glad to come here to make you share your experience with us. Believe me, there are several issues regarding the topic which should be defined correctly. While we are aware of and can more or less define what is the freedom of expression, there is no clear understanding what is religious feelings. And even more, it is hard to define the meaning of heart feelings. To understand someone's feeling is a matter of our own feelings. This is difficult to identify the level of heart feelings. To understand someone's feelings and the matter of our disposition, this is the matter of our disposition toward a person or group of people. How much someone's feelings are hard, it's also very difficult. That's why I'm putting these questions to discuss it with you. As I mentioned before, we are talking about that a lot, not discussing, but talking too much. Recently, the issue was the amendment in law about culture, which also was talked in the frame of controversy of the topic of my topic. For a long time, we used to read in the law that work of art could be restricted out of publication in case it violates other people's rights and etc., but without reference, who should judge it? Now, the amendments say that this should be a judge within the frame of private law. Actually, okay, who else could judge it? But the question was, is the judge prepared for that properly? How he or she could judge the case? Of course, some could say that this is not a legitimate question because judges are there to judge regardless of difficulty of the issue, difficulties of the cases. But we are not talking about who is guilty, which is the case usually. The question is, what is the violence itself? Where is it and who is the violating what? What is the work of art? And could it violate someone's right? Can we define the caricatures of Charlie Hebdo as a piece of art? Can we say that it was heart feeling of Muslim people? Of course, there is no excuse for violation, especially for terrorist attack, but if reaction were different, if Muslim people reacted with the peaceful protest, could we say that it would be rightful? Could we say that Charlie Hebdo's activity was violative? I suppose we'll never achieve the consensus between the parties. In that case, what could be the judgment? Is that depend on which party representative judge is? Another issue I would like to touch is the political correctness, which is a kind of restriction to freedom of expression, and especially modern practice of it regarding religions. In the societies with religious majorities in Europe, and first of all I can speak about my country, we accept critics of religion beliefs, practices, and even theology of one, while at the same time criticizing the same issues in religions of minorities, could be defined as Islamophobia or anti-Semitism or something like that. And this is not the problem with Islam or Judaism or other religions. This is the problem of practice of political correctness. This is a problem of our disposition with this value. All religions could be criticized, and all of them have what for, especially when we are speaking about their public practices and their behavior in the society, while at the same time, they all have to be respected equally from the secular society. Finally, as I can feel, because of the difficulties with the topic, a lot is about our own responsibility. We should be responsible individually. We should be responsible as a part of society. Media should be responsible, and yes, while the traditional media, as usual, has more resources than irresponsible individuals, it should take advantage of on digital platform, as well as bring the responsibility on it. Finally, media should bring the knowledge and understanding of the difficulties of the contradiction. It should bring the platform for better knowledge of each other and better understanding of each other. Thank you.
Thank you very much, Georgi, for that. It also adds, I think, to the list of topics that we put on the table, and we will indeed open now the floor for questions and comments. Just to give you an idea, we intend to conclude this at about 3:15, 3:20, when we'll go to Esmeralda Moscatelli for a very short wrap-up session. We also have the remote moderator with us, Virginia, so we'll be able to add to the questions from the floor whenever the need be. So we are opening it up. Just a kind request to everyone, please shortly introduce yourself, state your affiliation, so we know, and the speakers, the panelists know who they interact with. Floor is open. It takes a while, probably. Maybe I can ask Menno whether he wants to break the ice.
Yes, I can try to break the ice and try to bring in also some new perspectives. I've appreciated the various inputs because I think it really puts the finger in some of the challenge, or the finger on the sore spots and where the challenges lie. I mean, I think what was mentioned by peers, the balance is where the challenge, I think, lies in all these discussions. Where's the balance, and how do we work on that? And I think if this session is also about seeking solutions and challenging the solutions in the possibilities, I think finding this balance really needs, and this is where I want to bring in a new point of the educational and awareness raising approach, and to bring in the broader political, broader society in the debate. We really also need to think of the awareness raising elements to the discussion, to capacitate people to be critical consumers of news, of the internet, and use these tools. Especially when we look into self-regulation and calling for more transparency, the question is, do we also understand, and the people that use the methodology, the platforms, do they actually understand the information that they are provided? I think there's the challenge here still on educating people to understand what are the risks and opportunities when it comes to privacy on these platform settings, the opportunities and the risks of consuming media, the sources, checking the resources, and to also understand if there's redress mechanisms. Okay, when do I use these redress mechanisms, and what are my expectations, and how do I put my case forward. I think there's a lot of need also to look into educational elements to it. And in that sense, I think the Council of Europe is also trying to strengthen this comprehensive approach. For example, with ECRI's, the European Commission Against Racism and Tolerance had a policy recommendation, number 15, on combating hate speech, where it really seeks to have a very comprehensive definition on hate speech, for example, but also calls for regulation, self-regulation, but also really calls for promoting human rights narratives or alternative narratives, counter-narratives, more education and more victim support. I think that's also a perspective we need to see in. And in that sense, for me, part of the discussion on the freedom of expression is also the freedom of expression of who. I think there's also a consideration to see that we have national minorities, for example, speaking of the LGBT community, that they're part and parcel of this discussion in the regulation, and that they also can fully take part in designing regulations if needed, but also designing self-regulatory methodologies that are involved in this process. So civil society should be also involved. So I think these are some of the struggles we are looking at. And if I now look at the Georgian situation, we just had a session on the situation in Georgia, where we see we got the comments that there's quite good legislation in Georgia. It's on freedom of expression, for example, protecting it. But when it comes to implementing, the capacity is lacking with judges to understand the issues at present and how to implement it. The police is also not able to follow up on complaints. Civil society is also not organized to actually bring forward points. So there's a need to seek all partners involved. And the question is, how do you do that, and how do you get everybody involved?
Thank you very much, Mana, for that. It's a good addition, I think, bringing in the education and awareness-raising elements, as you said. Again, the floor is open for comments and interventions. Please.
Yeah, if there's nobody having a question or comment at the moment, I would like to say something. I'm certainly also of the opinion that this is not an issue for state or European Union or whatever interference. In Zimbabwe, they created the Ministry for Communication, which was also to control the internet, and the minister very quickly got the nickname Minister WhatsApp. Yeah? So this is what people are not really need. But on the other hand, we have also to see that the situation is different from what our assumptions usually are. Our assumptions usually are that there is a remedy through the diversity of media. Yeah? So if you find in this media a certain information, then you can check it with information in other media. But if people are living in their echo chambers, in their filter bubbles, in big platforms like Facebook, you do not get, you are not confronted with this diversity from the moderators, so to say, of content moderators of Facebook, because they pursue a certain line. And on the national level, we also have institutions which are not necessarily interfering into the performance of the media, and these are independent regulators. So if we need independent regulators on the national level, why don't we think about some form of regulation independent also on the international level? Isn't there a need for something like this where one could get together and in cooperation with the platform set up some mechanism which has a due process, which is transparent and so on, and which might deal, let's say, with border cases or give guidance or similar. I'm all for the balancing. For example, the European Court of Human Rights is requesting the national level to do this balancing, and if the balancing comes to a certain conclusion, he will accept it because balancing has taken place. But what do we know about balancing in internet platforms, by internet intermediaries? Do they have the time? Is this balancing inbuilt into the algorithm? We do not know. And therefore, I think there needs to be a public debate. All these platforms also always say that yes, we are in favor of multi-stakeholder approach, but in practice they have expert committees self-selected to advise them. They are shying away from the public debate of their approaches. And this gives us the feeling that something is maybe not perfect, because otherwise they could discuss it in public. Thank you.
Thank you for that. Please.
Thank you all very much for your presentations. My name is Nadia Chechia, and I represent the Youth Coalition on Internet Governance. And I would like to direct my question to Professor Benedek. And perhaps if I have made a false connection, please correct me. But you mentioned regarding the European Court of Human Rights, the different algorithms that need to be discussed, and specifically that there needs to be a basic understanding and how we can participate in this. So I vaguely recall that there is a series of trade negotiations at the WTO and FDA, and I think also RCEP, where they're discussing bans and restricted access to particular algorithms to protect e-commerce and trade secrets. So when you mention participate and basic understanding, do you mean access to source codes? Do you mean, so in what aspect do you perceive the participation of the technical and civil society community? And in terms of the discussions, I don't know if this is within your realm of discussion, but would it be possible for tech and civil society to participate in organizations like the WTO and RCEP, for example? Thank you.
Yes, thank you very much. I mean, when I mentioned the European Court of Human Rights, you know that they receive around 60,000 applications every year. And in the filtering process, it seems they are using also algorithms which help them to identify whether this is a true complaint based on the violations of rights under the European Convention of Human Rights or not. Yeah? Well, what you mentioned regarding the WTO debate, e-commerce, that's a totally different area. I mean, here we are dealing with trade law, and part of these intellectual property rights is indeed trade secrets. Yeah. So you can have a protection of trade secrets, it's part of this system, but what I have suggested was not that you have to reveal exactly the algorithm in any detail. What I have suggested is that you inform your users about the principles, about the basic configuration, so to say, so that they understand which elements are there and which have which relevance in the algorithm. And I say if that is possible to use algorithms in human rights context, then maybe it is possible also to have this kind of human rights by design built in, like privacy by design, why not freedom of expression by design, built in, and certainly that needs to be discussed. And if there is no willingness to do so, then I think self-regulation is becoming risky for the users, and that attracts then proposals for regulation from the outside, which is not what would be my preference. Yeah.
I want to complement what Wolfgang is saying. First, as has been correctly remembered, we have dealt for many years human rights problem through commerce law, the Electronic Commerce Directive. We are talking of taking down as something that is in our tradition. We never had this in our tradition. If I publish on my website as a broadcaster something wrong, even if I take down 1 second after I published, I'm fully responsible for it. I go to jail if it's something defamating somebody. In some countries, I have to pay huge fines. I can suspend it of my journalistic license, etc., etc. If I do on Facebook, or if somebody publish on Facebook, then the only obligation of Facebook is that within a certain delay of time has to take it down. So there is something wrong there, and I think that we need to come back to the essential that when it comes to human rights, the human rights cannot be bartered against trade or against anything. They come as a first value for a society. The second point that I want to make clear is the example that we have of self-regulation have not worked. The right to be forgotten is self-censorship, self-absolved, self-indulged by the same company that provoked the problem. I give you an example very concrete I mentioned briefly yesterday. BBC keeps a record of all the items that they publish on the website that have been taken down by Google because of the Right to be Forgotten Act. And they were at 60 6 months ago, and I think that now they could be at, I don't know how many. And they believe that a certain number of these items has been taken down, were taken down with arbitrary reason, but because nobody knows which criteria were applied, who applied, and because the expert list that is making the analysis ex post of what happened is not open, it's a black box. Can, as a society today, live in a black box when it comes to human rights? I don't think so. Third point, and sorry to be long, it is about algorithms. There is a very commendable initiative of the Council of Europe within the CDMSI that is Artificial Intelligence and Media working group. I'm part of this group. I'm proud to be the part of this group because as a journalist, I don't understand nothing of nothing, but I listen and I try to learn. And I learned in the first meeting of this group 2 months ago something very important, that an algorithm is not a unique body. The algorithm has a first part, a second part, and the third part. The first part is what you want to get through the algorithm. Okay? The second part is, once that we have agreed what you want to get through the algorithm, then you put all the equations that are needed to get the objective that you have stated. And then the third part is a self-assessment if there is a match between the working made by the algorithm compared to the original scope. I don't care what is in the second part. I would care very much to know what there is in the first part, because most of the problems that we are discussing now are exactly that in the first part, for this company, the first thing is how I can make more money out of it. That's the real reason why. And this is something that probably you need to discuss, and as society, as civil society, as media, we have the right to argue that society is not only based on making money, that there are limits to the money that you can make. When I discuss with my Facebook colleagues coming from the media sector, because now there are some working for them, I say, you forgot that every newsroom journalist that I hired in my life, the first thing I ask him is to fact-checking everything twice. Now that you are doing the same job in mine, why you are not submitted to the same rules? Because practically we are doing the same job. So there is something that we need to stand up, and we need to, and the solution for me is that cooperative solution, because all of these topics has been afforded, like the one mentioned by George and colleague, are things that the journalists assess and solve every day in their job. Why we have to go to look for experts somewhere else? Go work together and try to assess which are the right solution. Yes, of course, it costs less to take 1,000 people and put in a hangar in Dublin or in Germany and give them algorithms to do the job. Unfortunately, society is complex, and this cannot be solved, everything. Sorry for being long.
Okay, thank you. I have first gentleman on the left and then Piers.
Hi, I'm Eduardo Santos from D3, a digital rights organization from Portugal. I have some questions or comments to Mr. Piers O'Donoghue. Sorry for the pronunciation. You said that it was so important not to have general monitoring obligations on tackling illegal content online. But in the copyright case, there are general monitoring. Article 13 requires general monitoring because it requires that 100% of the content that is uploaded should be tested against a filter. So why is copyright different from the other subjects? And we know that filters don't work only for illegal content. We know that they also will have problems with parody, like you said, the free uses, the exceptions, or what the Americans call the fair uses, that are rights of the citizens to express themselves. So I want to ask you if you really think that it's a justifiable cost that you said, that it is fair or justified to restrict freedom of expression of the citizens just to give funding to journalists and rights holders. It's the only option to do that is to restrict the freedom of expressions of citizens with filters. Were there any impact assessments on the consequences of this legislation? Thank you.
Thank you for the question, and perhaps then I can come on to something that Giacomo said, but I wanted to give a precision. But first of all, just to clarify, you quoted me back, but when I said about no general monitoring obligations, that was in relation to the e-commerce directive and what we have now proposed to supplement that in relation to illegal content, which is the recommendation on illegal content, which, by the way, is not law, it is a recommendation. But what we have in relation to illegal content, before I move on to your question, I know was focused on copyright, is that there should be an ability to systematically monitor and to use automated means. But because of the use of automated means, we then have to address even more seriously the weakness which Giacomo spoke about in the past, and was even in the example which you gave about Facebook, which is that clearly we have to have absolute transparency upstream and downstream of this filtering process, as you call it. I will not call it a filtering process. But upstream and downstream. In other words, that what we have now recommended is that the intermediaries, the entities, they need to have a transparency policy, which means that ex ante they have to explain what their policy is, and ex post of any decision to take down, they actually have to explain that. But what is just as important, and again to really fill in the lacunae, the weaknesses that have been recognised, we need to have an independent means of challenging any such decision. And that is very important to making this system work. Now, in the specific context of your question, which I know was in relation to copyright, of course, if you say, and if you ask me the question, is it a legitimate cost just to support journalists to restrict the freedom of expression of citizens? Of course, if I answer yes to that, it can be well quoted and misused. But I did in my presentation try to make a more reflective analysis into why this balance was required, as to why it was in order, first of all, to protect rights holders. Because there is a right there, people who have created material, created content, and they do have the right to have it protected. But there are a series of exceptions that you obviously are aware of, that I listed some of them, with regard to snippets, with regard to hyperlinks, with regard to parody and so on, where those rights are waived. And the copyholder's right is not an absolute right, and that has been made clear both in our proposal but previously in Court of Justice law. So it is acceptable to have some trade-off to protect the future viability of journalism, of quality journalism in the European Union, which is itself fundamental to supporting democracy, to pluralism, and therefore to a democratic framework which allows the freedom of expression. Because if we just look to our partners across the Atlantic, although they're on hopefully not a very slippery slope, one has to ask themselves, as the journalism becomes more partisan, and as the ability to attack others without any redress becomes stronger, how is that supporting plurality, democratic discussion in that country? So, of course it's not. We would prefer not to have to make these trade-offs. And we certainly, by the way, don't think that we're in a position to make these judgments on our own. We have made proposals which are with the co-legislators, and each of the mechanisms that I described in turn will rely on regulators. We haven't got so far as talking about independent regulators, on transparency, and making sure that those who audit and check for compliance are totally independent of us and of government.
Thank you very much. For just 1 minute each, I'll go to Natalia and Georgi, who have announced their intention. And then we'll go to Esmeralda as we approach the time limit of this session. Please.
Yeah, I will keep my intervention short. And for me, the biggest question of this session and EuroDiG is the role of the platforms. And I see it very visibly that we are still not capable of answering this question, because platforms appeared in this human rights ecosystem. They are very powerful players right now. And it's tempting for states, for example, to hand over the protection and some responsibilities in this field for the platforms, because platforms are effective. That's really true. So they are the one capable of, for example, monitoring, filtering, like taking down and regulating what we see and what we cannot see. But on the other hand, platforms are not newsrooms. They are not newspapers. And I believe that we all don't want them to be newspapers. Because, you know, if it becomes newspaper and I'm not quality journalist and I don't have proper education, I don't have other place to go to express myself. So for me, and I don't know the answer. The question is, how shall we really embody platforms in the human rights protection ecosystem, and how to make this system sustainable? I don't know the answer, but for me, from this session and from the previous sessions as well, that's the biggest question we are facing, and it's really a pity we don't have any platforms in the room right now. Thank you.
Go to Georgi.
So I will go on with Natalia, because yes, we need really the platform for discussing these issues. I believe that that discussion about my topic, especially, I can speak about that. I mean, it's somehow coming to our country. I mean, because this is a really important issue right now. When you have in a country the majority of one of the religions, and they are really active and they are really proactive to express their religious beliefs, religious practices on the public, and this is really always really very important, and especially when there is, on the contrary, there is a part who is expressing their freedom of how to say that, to contradict themselves to this kind of expression of this kind of religious beliefs and religious practices. So this is kind of, let's say, not actually the new challenge for us. This challenge is existing with us during all these 27 years of being independent from the Soviet Union. But anyway, we are, I do believe, and I would like to believe, that we are ready right now somehow to discuss this, academically discuss this issue, and qualitatively discuss this issue. And what I would like to ask you about is kind of to somehow to share your experience with us. I mean, not on the floor of this event, but also on the next meetings, on the next occasions, to really to share your experience. When I was preparing for this issue, I found out that this discussion is really active in Israel, for instance, because Israel community also discussing where is starting religious feeling and where we should start speaking about religious feeling and stop talking about freedom of expression, and on the contrary, and on the vice versa. So I do suppose that we need bigger platforms for these kind of issues, and these issues are really very active right now. especially maybe even in Europe, as I can see, because the rise of Islamic communities inside Europe is really very obvious. So thank you very much for this kind of opportunity to speak about these issues. And yes, we are do think about that. And inside our public broadcaster, we do think to finally to put on the floor the platform for really qualitative or really academic discussions of this kind.
Thank you, Georgi. Very briefly, please, and Esmeralda will give me...
I will try, just because many things have been covered. Just want to say that, again, transparency is not enough if the information provided are not made as accessible. And, again, the failure of the multi-stakeholder approach if it's not representative, because I think we have a huge problem of representation. Who makes the decision has been said that, if it's not representative of all, like really representative of all the parts involved, it will be failed. Also, the Professor Strickling said that many times, and I think we still have a huge problem of representation when it comes to decision-making bodies. And I was really happy that I think I heard the word feeling just from the, I don't remember the name of George, because I think we're talking about algorithms, and I'm happy we talk about education, because I think that if we talk about human rights and accessibility, we shouldn't forget the ability also to push for empathy and critical thinking, which, is totally missing from all these arguments. And I think when it comes to hate speech and talking about protecting rights of people, it shouldn't be missing, and it should come through education and a real peer-to-peer dialogue, which is now missing. So I wanted just to point out these things.
Thank you, and we go now to Esmeralda, right?
So, hi everybody, this is Esmeralda Moscatelli from the International Federation of Library Association. I'm here because I help organize this workshop, but I'm not the Geneva Internet Platform person who's coming after me. Aida is there. So I was asked to briefly touch upon the remedies that they were discussed here, but I'm going to be very general. And so it seems to me that when there is a consensus from everybody, then when our human rights and fundamental freedoms are either restricted or violated, we must have the right to a remedy. So, but the ways for us to seek this remedy should be in a way available to us all and accessible and fully representative. I heard that we often talk and discuss and we hear with the idea of this multi-stakeholder, which is very nice and fine, but some of the actors are shying away from public discourse related to this matter, so this is something that we have to think about. And also we have to think about solutions and remedies that are capable of providing a real practical solution to tackle the problem. So the effective remedy should be or could be obtained from internet service provider, and we heard, I think, in general about the lack of some credibility, transparency issue. Why don't we have international regulator in cooperation with this platform that could sort of highlight a certain due process and the issue of balancing, reiterated by many people, is important, but do we have it these days? Yes, no, there's ample room for discussion there. And then also, why is credibility, when we talk about internet service provider, their credibility at times is not called into question vis-a-vis the sort of more established media fact-checking tradition that we had in the past, and I'm talking about analog media. Also, effective remedies should be obtained for public authorities and any other human rights or government institution involved. And Mr. Donahue talked about auditing and monitoring tool that we don't really have, and the fast pace of this is sort of biting our tail. So is self-regulation a remedy? Is becoming, you know, like from users, this is becoming very risky and at times ineffective. And the right of to be forgotten was called in question. And I think in general, effective remedies, as you have highlighted, should sort of tackle real matter, clarify issues, and be accessible to us all.
Thank you. And then we move to Aida.
Thank you, Esmeralda. My name is Aida Mahmutovic. I'm here in front of Geneva Internet Platform, Digital Watch Observatory. You can find full summaries of all of the sessions, including this one, at dig.watch, as well as EuroDiG wiki page. Now what we have here are, and just to say that, Esmeralda, we will also include those remedies that you just told us. Now, I have here session messages, and what we are trying to do is to kind of get a rough consensus in the room, and we can do that. We're not inviting for a discussion, but you can just show thumbs up or thumbs down, and I will note if we have it or not. It's okay to disagree. One, there should be more transparency on how algorithms are developed and a public debate on the approaches private companies take. Right. Two, when discussing ways to tackle disinformation, we need to assess the implications for both democracy and freedom of expression. Cool. Quality journalism is essential for maintaining democracy. Okay, I see smiles, that's also good. 4, since traditional media has more resources, it should take advantage of a digital platform and bring responsibility to it. Should I read again? Because I was, okay. And 5, yeah, if you need to change a wording, to repeat, okay. Since traditional media has more resources, it should take advantage of a digital platform and bring responsibility to it. This is what one of the speakers... Yes.
And actually, in my words, it was that traditional media, I mean the big broadcasters and media producers, has much more resources than some of irresponsible individuals, which are using the social media for fake news or disinformation and something like that. In that case, I do believe the traditional media should invest more in the digital platforms and to bring this kind of responsibility or quality of journalism on the digital platforms as well, on the social media and so on. Yeah.
In terms of it,
yes, it is. Yeah. It has better equipment. It means huge amount of human resources, qualitative journalists, and so on, which should be exceed in, let's say, exceed in amount all the information which is put it on the digital platform.
Okay, so would you guys agree to rephrase it a little bit, and you will help me just right after the session? Would that? Yes. Okay. 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 And the last one. Finding the balance is important, and the educational awareness raising is needed in order to achieve that balance and to make people understand the information they are provided. Wait, like this? I see a little bit of this. Okay. Okay, I feel like we have 4 that we agreed on. Okay, thank you everyone for holding in there.
Well, thank you very much indeed, everyone. I want to thank again the speaker, Giacomo. Please, yeah.
Very rude what I did, but it was actually Natalia reminded me. For our purposes, we have an open consultation on our recommendation on tackling illegal content online. It's the second stage of the consultation where primary stakeholders already made recommendations about the next steps, yes. But we would really like to have the views of the wider community now on what might be the next steps. So it's on, the consultation is open until the 25th of June. I apologize.
No, and then I just wanted to say that we will have the chance to exercise our right to a coffee break, and then you are welcome to pursue and continue the discussions with the panelists or among yourselves. Thank you very much once again for participation.